Welcome to bongosikha. Today, aspirants, I am going to discuss about the Union Territory. So, first you have to know what are the Union Territories, and later on I will discuss the background, how it came into force, what are the constitutional provisions, everything I will discuss one by one. So, first, what is most important to know, that is the Union Territory. Union Territory means the Sanghashit Kshetra or Pradesh. So, Union Territory, Sanghashit Kshetra or Pradesh, federally administered province, is a type of the administrative division in the Republic of India. So, federal, they don't enjoy the states, means they, unlike the states of India, they don't enjoy their own statehood. Unlike the states of the India, they are having their own governments. Union territories are the federal territories directly governed by the central government of India. So this is the main thing, that they are like the states, they don't have their own governments, unlike the states which have their states in India. The states, as we know, 29 states, they are having their own governments. But in case of the union territories, they don't have their own governments. So that is the main difference between the states and the union territories. So union territories are directly governed by the central government of India. Now I will discuss about the background, that how territorial union territories that came into being. So as of 2020, means till now, that there are 8 union territories. But when the constitution was adopted in the year 1949, then there was only Group D state, that is Andaman and Nicobar Islands. So after that, three more, that is Delhi, Lakshadweep and Chandigarh. These three were formed by separating each territories from the pre-existing states, and two more, that is Dadra and Nagar Haveli and Daman and Diu and Puducherry, were from the acquired territories which were formerly or previously belonged to the non-British colonial power, that is Portuguese India and French India respectively. So this is the history, that how this all union territories came into being. At first, in the when constitution was formed or adopted in 1949, then there was only one Group D state, that is the Jammu, Andaman and Nicobar Islands. Thereafter, these territories came into being. The Parliament of India can pass a law to legislate or to amend the constitution, and provide a separate legislature with the elected members and the chief minister, as it has done for the Delhi and the Puducherry. In general, the president is the main responsible or is the administrator of the each union territory, and he specifies the role. He appoints a representative who will act on behalf of the president, who will govern on behalf of the president. He may be a lieutenant governor, he may be chief administrator, or he may be an administrator. So president in general appoints an administrator or lieutenant governor for each union territory. So Parliament of India can pass a law to amend the constitution and provide a legislature for each union territory with elected members and a chief minister. So Delhi, Puducherry, Jammu and Kashmir, the working of these union territories are quite different from the other five. As I told, that as of 2020, there are 8 union territories. So out of 8 union territories, 3, that is the Delhi, Puducherry and Jammu Kashmir, they operate differently from the other 5 and they enjoy a partial statehood. And Delhi is renamed as the National Capital Territory of Delhi and incorporated with a larger area, that is NCR, that is National Capital Region. So Delhi, Puducherry, Jammu and Kashmir, they have their elected legislative assembly and an executive council of ministers, and they enjoy partial state-like function. So this is the case of the Delhi, Puducherry, Jammu and Kashmir apart from the other 5. So total 8 union territories. So these three, the Delhi, Puducherry, Jammu and Kashmir, enjoy partial statehood or the partial state-like function they enjoy. In August 2019, the Parliament of India passed Jammu and Kashmir Reorganization Act of 2019. This act this act contains the provisions to reconstitute the Jammu and Kashmir into two union territories, which was eponymously known as the Jammu and Kashmir and the other Ladakh on 31st October 2019. In November 2019, the government of India introduced legislation to merge the union territories, because earlier I told right now that there are 8 union territories, so Dadra and Nagar Haveli, Daman and Diu, and the Puducherry, they were formed from the acquired territories which were formerly belonged to the non-British colonial powers like Portuguese India and French India respectively. So in November 2019, the government of India introduced legislation to merge the union territories of Dadra and Nagar Haveli and Daman and Diu into a single union territory, which is known as the Dadra and Nagar Haveli and Daman and Diu. So this is the background, that how these 8 union territories came into being. Out of this, that the functioning of the Delhi, Puducherry, Jammu and Kashmir operate differently from the other 5. They have their own legislative assembly and elected members, executive council of ministers. And they partly perform the state-like function. They enjoy the state-like statehood in partial type. So this is about the background, that what was the background behind the creation of the union territories. And union territories means that Sanghasit Kshetra or the Pradesh, federally administered territory or the province. So this is the main thing. Now I am going to discuss the constitutional status. So constitutional status, Article 1 of the Indian Constitution describes India as a union of states, which are elaborated under Part 5, the Union, and Part 6, the states of the constitution. So the concept of the union territories were not in the original constitution. It was later added by the 7th Amendment Act of 1956. In the constitution, wherever it refers to the territories of India, it is applicable to both the states and the territories of India. And in where it refers in the constitution, where it refers only the India, it is refers only to the states, and it is not applicable to all the union territories, but not to the union territories. Thus, citizenship, fundamental rights, directive principles of state policy, judiciary role, Article 245, union territories, these are applicable to the union territories because it refers to the union territories of India. And President of India is the chief administrator of the union territories. For the control of the union territories, is the chief administrator of the union territories under Article 239. So President is responsible for the administration of the entire union territories of India under Article 239. This is very important, that President is responsible for the administration of entire India under Article 239. So we know from here that originally there was no union territories mentioned in the constitution, because Article 1 describes India as a union of states, and Part 5 deals with the union and Part 6 deals with the states. It was later added by the 7th Amendment Act of 1956. And that is why all this is the citizenship, fundamental rights, directive principles of state policy, judiciary role, then union territories, all these are applicable to the union territories, specifically to the territories of India, because it refers to the territories of India, and President of India is the chief administrator of the union territories. Now, administration of union territories. Articles 239 to 241 under Part 8 of the Constitution deal with the Union territories. Articles 239 to 241 under Part 8 of the Constitution deal with the Union territories. Even though all the Union territories belong to the same category, all the Union territories are the same, but still their administrative system is different from each other. There is no uniformity in their administrative system. Although all Union territories belong to the same category, but their administrative system is not the same. There is uniformity, there is no uniformity regarding their administrative system. So every Union territory is administered by the President of India, as I told right now, and he acts or he controls his administrator by appointing an administrator on behalf of him. So here it is noteworthy that the administrator who is appointed by the president for the administration of that particular union territory is not the head of the state. He is not the governor of the state. He is an agent of the president. He is an representative of the president. So he is not the head of the state like the governor of the state. And the president here has the discretion to specify the designation, whether he will be called the lieutenant governor or the chief commissioner or the administrator. That completely depends upon the discretion of the president. And president is the sole administrator of the union territories. So an administrator of the union territory is an agent of the president, which is very important. You have to know all the time. Now the parliament has the power to make laws on the three subjects, including the state list. And this power of the parliament even extended to the Delhi, Jammu and Kashmir and Puducherry, which already have their own legislative assembly legislatures, local legislatures. But the legislative assembly of the Puducherry can make laws or entitled to make laws over any subject on the state list and the concurrent list. Likewise, the legislative assembly of the Delhi can make laws on any subject of the state list except public order, land and police and the concurrent list. And likewise, the Legislative Assembly of the Jammu and Kashmir also can make laws on any subject of the concurrent list and the state list except land, public order and police. So these are the administration, how union territories will be administered. Mainly the president is solo responsible for the administration of the union territories. He appoints an administrator who will act on behalf of him, because it's not possible for president to take the overall care. So he specifies the designation, whether that appointed person will be called lieutenant commissioner, lieutenant governor or the chief commissioner or the administrator, like that only. So this is the role of the president in the conducting of the election, means the administration of the election commission. So the parliament has also the powers on making of the laws on three subjects, including the state list. Only limitations are there that the Legislative Assembly of the Delhi, Puducherry and Jammu and Kashmir can make laws on any of the state subject except three matters, that is the police, land and public order. So they cannot touch in these subjects. Next, the president can make regulations for the peace, progress and good governance. The president is responsible for making regulations, to make regulations to that inculcate peace, progress and good governance of the union territories like Dadra and Nagar Haveli, Daman and Diu, Lakshadweep, Andaman and Nicobar Islands, then Ladakh. So in the case of the Puducherry, the president also can legislate by making regulations, but that is possible only when the legislature is the assembly, that legislative assembly is suspended or is not in session or dissolved. So only in that case, in case of Puducherry, the president can legislate by making regulations, because we know that Puducherry early by citizenship, when I was discussing about the citizenship, that time I also discussed that Puducherry was when ইন্ডিয়ার সঙ্গে যখন পদুচেরিকে অ্যাড করা হলো, যখন পদুচেরি ইন্ডিয়ার অধীনে এলো, তখন সিটিজেনশিপ অ্যাক্টের মাধ্যমে পদুচেরির সমস্ত যারা সিটিজেন্স, তাদেরকে ইন্ডিয়ান সিটিজেনশিপের আখ্যা দেওয়া হলো। আদারওয়াইজ পদুচেরি কিন্তু প্রথম থেকেই ইন্ডিয়ার অধীনে ছিল না। সুতরাং এটা ইউনিয়ন টেরিটরিজটা পরে সৃষ্টি হয়েছে, যেটা আমি যখন ডিসকাস করছিলাম আগের সিটিজেনশিপের সময়, তখন আমি বলছিলাম যে পদুচেরি ব্যাপারটা কিন্তু কমপ্লিটলি আলাদা। পুদুচেরি সিটিজেনশিপ অ্যাক্ট পরে যেটা হয়েছে, কারণ পদুচেরি যেটা শুরুর দিকেও বলছিলাম যে পদুচেরি কিন্তু মানে তৈরি হয়েছে যে অ্যাডমিনিস্ট্রেট ফ্রম অ্যাকোয়ার্ড টেরিটরিজ, যেই টেরিটরিজটা আগে নন ব্রিটিশ কলোনিয়াল পাওয়ারের আন্ডারে ছিল, পর্তুগিজ ইন্ডিয়া অ্যান্ড দ্য ফ্রেঞ্চ ইন্ডিয়া, তার থেকে কিন্তু দাদরা, নগর হাভেলি, দামন অ্যান্ড দিউ অ্যান্ড পুদুচেরি, দে ওয়্যার ফর্ম ফ্রম দ্য অ্যাকোয়ার্ড মিনস টেরিটরিজ। সো পুদুচেরি শুরু থেকেই ইন্ডিয়ার মধ্যে ছিল না, যার জন্য পুদুচেরি সিটিজেনশিপ অ্যাক্টও পরে করা হয়েছে, যার মাধ্যমে পুদুচেরি সিটিজেন্সদের ইন্ডিয়ার মধ্যে ঢোকানো হয়েছে। সুতরাং এই ক্ষেত্রে কিন্তু প্রেসিডেন্ট মানে ইন দ্য কেস অফ দ্য পদুচেরি, দ্য প্রেসিডেন্ট ক্যান লেজিসলেট, মানে প্রেসিডেন্ট হ্যাজ দ্য পাওয়ার, প্রেসিডেন্ট করতেই পারে, কিন্তু সেক্ষেত্রে বাই মেকিং রেগুলেশন, যখন অ্যাসেম্বলি ডিসলভ থাকবে বা যখন সাসপেন্ডেড থাকবে, তখনই প্রেসিডেন্ট এ ব্যাপারে হস্তক্ষেপ করতে পারেন, আদারওয়াইজ কিন্তু নয়। তো সেই ব্যাপারটা গেল ইউনিয়ন টেরিটরিজের ক্ষেত্রে। তো এটাই হলো ইউনিয়ন টেরিটরিজ, যেটা এতক্ষণ বললাম যে প্রথমে শুরুর দিকে এটা ছিল না, কিন্তু এটা ল্যাটার ইউনিয়ন টেরিটরিজ ওয়াজ অ্যাডেড বাই দ্য 7th অ্যামেন্ডমেন্ট অ্যাক্ট অফ 1956। সো তারপরে এটাকে অ্যামেন্ডমেন্ট করে এই ব্যাপারটাকে নিয়ে করা হলো যে ইউনিয়ন টেরিটরিজের ব্যাপারটা ঘোষিত হলো, এবং তার মধ্যে যেগুলো পড়ছে, যে সিটিজেনশিপ, ফান্ডামেন্টাল রাইটস, ডাইরেক্টিভ প্রিন্সিপাল, সবই এগুলো আলোচনা করা হয়েছে। সো দিস ইজ অল অ্যাবাউট দ্য ইউনিয়ন টেরিটরিজ। আই হোপ ইউ অল হ্যাভ আন্ডারস্টুড ইট ভেরি ওয়েল। সো থ্যাংক ইউ।